Please confirm all of the
Okay, so ni bahasha mzee kwa hii bahasha. Sawa. Shall give them. Hi, welcome. Confirm that all the needs are there. All of the scores inside that bahasha. All of the six. It's supposed to be 8. Come on. 4. One more judge is left. So, as we wait for the judges, please note 2 things. 1, court demeanor. 2 words. 2 words. Or answering questions. Yes. Court demeanor and answering questions. Yes, and also your excellencies. Your lordship, my lady, my lord. This is not ICJ. This is not an international court. This is before the environmental law court. Number 3, good citation. Cite your cases properly in full. Give the full name. If you can guess the paragraph, yes. If you don't want to guess the paragraph, don't. If you want to lie about the year, you don't know technically. So give the full citation. Yes. And what else? Applicants, make sure you prove. If you want to prove something, prove it in full. Respondents, if you want to respond in full. Do not leave some response hanging. Noted that in the previous round. And please speak close to the mic. When I'm outside, I'm supposed to hear you guys from the live stream. So please speak close to this mic. And also, judges, Ramani, please, when you're going to speak, you have a faint voice. Some questions are put on the screen. And when you don't use the mic, you speak stuff. So please use the mic. Karibisha mic kusikia. Like the way him and him usually do on skip and food. Please use the mic. Yes. Pass the chat on the mic, but make sure if you want to ask a question, use the mic. Yes. Chat after shower. Yes. Session. She didn't answer my I think they told you they told her that for transparency, they don't have to so the person can come back to that. If you think it's not here. We have a way.
The court is in session. The matter in court is of the Republic of Malindi in the Environmental and Land Court at Nairobi, petition number 8 of 2024 between Kasiri Community Organization and 2 others versus the Attorney General and 2 others.
So, greeting councils, my name is Bashir Duncan. I'll be presiding this session. And let my colleagues introduce themselves. We will begin with the one on my right.
Good evening, councils. My name is Zarina Chentai, and I'll be judging this session. Good luck.
Good evening, councils. I am Amani Andika and I'll be co-judge and I look forward to hearing the submissions.
Greetings. My name is Shimon Prowess.
So the rules of the round have not changed. The time allocation, you allocate the 20 minutes among yourselves as you so wish, will be more strict on time. Only the petitioners will issue 2 extra minutes for rebuttal, as we did in the other rounds. Only one team will proceed from this round, so it's a knockout, purely based on orals ranking from the 4 judges. So we should be having the results, I guess, after the round. It's 5:44. Let's begin 5:45 with the council for the petition. So in a minute, council for the petition and the floor is yours.
Can we just quickly say your team codes?
Team code 20.
You said 27, yeah.
Greetings, sir. Greetings, honorable members of the bench. My name is Matthew Nyagia. May it please this court, my name is Matthew Nyagia, representing the applicants. With my co-counsel, Midi Lachelle, we plead to use the 20 minutes allocated to us. I will spend 10 minutes to address issue 1 and 2, and she will spend the rest of the 10 minutes to address issues 3 and 4. With the permission of the court, I request to proceed to my submissions. On to our first issue, the petitioners assert that this court has jurisdiction and it has also local standing, and the cases presented before it are admissible before this court. Proceeding to our first limb of argument, jurisdiction, we as the petitioners submit that this court has the requisite jurisdiction derived from Article 162(2)(b) of the Constitution, which states that the Parliament shall establish courts with the status of the High Court to determine cases on environment use, occupation of, and title to land. Under Section 13 of the ELC Act, it further describes the jurisdiction, giving ELC the power to determine over environmental issues. In the Harissa Chenga and 2 others versus the Republic, the Supreme Court, whose decision is binding before this court, clarified on the jurisdiction of ELC, stating that it has exclusive jurisdiction in matters related to the environment. Proceeding to the next limb of argument, which is local standing.
Council, before you proceed to the other issue, addresses on jurisdiction as far as issues C and D are concerned, specifically issues C and D. Issue C on transboundary harm, issue D on public participation as a right in the Constitution.
Much obliged, my lord. I'll answer your questions as I proceed to my submissions, since it is well described.
Proceed, Council.
On the next limb of argument, local standing, the petitioners have local standing in person to Article 22(1), which grants every person the right to appear before a court if they believe that the right to a clean and healthy environment is infringed or violated. Also, under Article 22(2) of the Constitution expands the right to any organization and to any institution to appear on behalf of others. In the Momo Matemu versus Trusted Society of Human Rights Alliance and 5 others, the court emphasized that Article 22(1) and Article 22(2) and Article 258 of the Malindi Constitution allows for the societies to file suit on behalf of the public. This extends the local standard for all the applicants. Proceeding to the third group of argument, which is admissibility, to address on the question on jurisdiction. It is the petitioner's submissions that all cases presented before this court are admissible before this court. In Article 71 of the Malindi Constitution, it says if a person alleges that the right to a clean and healthy environment is infringed, the person may apply to a court for redress in addition to any other legal remedy available in respect to the matter. We submit as the petitioners that the doctrine of exclusion of local remedies is not absolute and it provides for exceptions. The court may waive the exhaustion requirement if local remedies are ineffective or unduly delayed, and number 2, if there is risk of irreparable harm, that is, if the cases are urgent before the court. We submit before this court under paragraph 23 and 28, which describes the part of the environmental damages caused by Talman Limited with the mining operations, causing the issue to be admissible before this court. We seek to rely on the case law of Republic versus NEMA and 2 others ex parte Daniel K. Kirui on the year 2016. The court allowed for application, stating that and indicating that while there are local remedies available, the urgency of the matter and severity on environmental harm justify application, meaning that the issues were admissible for judicial intervention.
Counsel, 2 questions on admissibility. One of the things that we usually question admissibility is the exhaustion of all local remedies. I want you to submit in line to that if the petitioners have exhausted all the local remedies that were required, and if you haven't, why would this court listen to you without the exhaustion of all local remedies?
Much obliged, my lord. Sorry for that. Much obliged, my lord. The issues presented before this court are urgent. As the petitioners, we had not exhausted all remedies, but the issues at hand are urgent and require judicial intervention and judicial review. And we seek to rely on the case law of Republic versus NEMA and 2 others, ex parte and Daniel K. Kirui on the year 2016, where the court admitted application since the issue at hand was urgent and required judicial intervention.
Counsel, can you show the urgency in this case?
Much obliged, my lord. I would like to guide this court to paragraph 28 of the fact sheet. Paragraph 28. In paragraph 28, aside we submit to the second issue, we see in the issue that the mining operations caused unprecedented rainfall, and when Talman Limited forced miners to go to work and to appear to work, and in paragraph 22, the second sentence, when 200 miners, both men and women, were working, the ground beneath suddenly began to shift. Then it swallowed 33 miners. Talman Limited, seeing the diverse challenges and effects caused to the environment, continued and forced its miners to appear at work. Therefore, the issue is urgent since under paragraph 31, I'd like to bring the court, under paragraph 31, where it is estimated that at least 300 people died because of the April.
We don't relate on the fact that people died. Let me guide you a little bit. One, on the Jaraba's Damia case, we had three things that need to be proven for you to bypass, or let's say bypass the of local remedies. One, it is its availability. Two, is its sufficiency. And three, is its effectiveness, especially on redressing the wrongs that are there. I want to get this court on how the local remedies that are available, right, cannot redress, or let's say address those matters that you provided. We have the local remedies. How can they address these matters? Before you just rush into court.
Council, just to clarify, we do not refute that the matters are of urgency. However, we still have something that the International Environmental Tribunal, which can still hear the matters even though they are considered to be urgent. Why did you approach the same?
We concede to the fact that issue 3 on the transboundary environmental harm caused to Samira might be put inadmissible before this court. But we submit before this court that since it is admissible and it requires a higher court, and it requires a higher court, the urgency of the matter leads us to a national court to address on the deaths and to hold Talman Limited liable for its causes to the environmental harm.
Council, tribunals are a court situation. They have functions which courts can also do. The question of the bench is simple. Why wouldn't you approach the tribunal first before approaching the High Court? Yes, the matters are urgent. Can't the tribunal address or redress these matters? Don't we have mechanisms in which we can address these matters before the court?
Much obliged, my lord. I seek guidance from the bench. I'd like to proceed to the next issue. Onto the next issues, but the petitioners assert that Talman Limited should be held liable for its causes of facilitating environmental harm and environmental degradation. Talman Limited has a duty of performing its operations with the responsibility to protect local communities. It has duty to uphold corporate responsibility and corporate social responsibility over its community. In paragraph, I'd like to guide the court in paragraph 25 all the way to 28, where diverse effects are laid out. But Talman Limited goes ahead to force its miners to attempt to work. This causing their demise, the demise of 33 miners. This is a breach. This is a breach of, sorry for that. This is a breach of the duty of care.
Council, I have a question. In concerns to the activities of Talman Limited, was the government of Malindi in control of the company? Because considering the fact that we are told that the company was an independent contractor, was the government in control of the activities of Talman Limited?
Much obliged, my lord. We concede to the fact that Talman Limited had been contracted by the government to do the mining operations, but it should bear the responsibility of protecting the community and not facilitating environmental harm. I would like to proceed to the submissions and guide this court to the case law of Wawero versus Republic in the year 2006, where the court held that every person has a right to appear before a court if the right to a clean and healthy the right to a clean and healthy environment is breached as provided by the Environment Management Coordination Act. The ruling highlighted the duty of care which must be owed by private and public companies and corporates. Under paragraph 23, there are complaints from residents that the river stand milky. This, we seek to guide the court into Section 9 of the Water Act 2016, which is a protection to the right to clean water. It requires that there must be protection and conservation of water, and Section 94 of the same Act. Section 94 of the same Act prohibits any activity that may lead to environmental harm. Under paragraph 23, as we see there are complaints from residents, Talmal Limited operations, mining operations, are directly connected with this diverse environmental harm. Therefore, it should be held directly liable. Under Section 3 of the Climate Change Act 2016, it mandates companies to reduce greenhouse gas emissions. Talmal Limited, for releasing emissions, Talmal Limited can be held liable under this act.
Council, don't you see the Talman Limited in paragraph 22? We see that the Kasili 7 project was able to remove and store 10,000 tons of carbon dioxide, with which the sale of carbon credit resulted in revenues invested in community projects. Don't we see this company directly remedying the situation of the emission by capturing and storing carbon capture and sequestration plan of 10,000 tons of carbon dioxide? How then will you submit before this court that this same company is emitting to the environment?
I would like to guide this court under paragraph 23 of the fact sheet, where there is a report. It is reported that 6 children between 10 and 15 years had received medical treatment for consuming the water. Additionally, cattle drinking water from the river were dying due to lime poisoning and acidic burns in the ruminant digestive system. This means that there was emissions to this water, and therefore caused the dying of flock, which was caused by the cattle drinking the water. And 6 children died because of the matter. Therefore, there was
still to the paragraph 23. Can you get us to see where it is proven that it is the Talmud company that is directly emitting to the water to make it both milky and dangerous for consumption?
Also, council, bear in mind that while you're answering that, there already existed various limestone deposits before the government project started.
Come again, sorry.
While you're answering the honorable judge's question, please bear in mind that there were already existing various limestone deposits before the government's project started.
Much obliged, my lord. After the government contracted Talmal Limited to conduct its mining operations. One, these mining operations can be connected to paragraph 23, where there were emissions to limestone deposits on the river. I'm getting the name of the river. On the river, causing the deaths of the children and causing the deaths of the cattle. Therefore, if we concede to the fact that there are existing limestone deposits, but after the government contracted Talmal Limited to do its mining operations, this caused the death of 6 children and the kettle by drinking the water. I'd like to proceed to my second hymn of argument.
Are you submitting that we see the death of 6 children?
No, not the death, sorry. They sought for medical treatment.
You proceed.
Much obliged, thank you. By prioritizing the profits, Talmal Limited disregarded its CSR obligation, and that negligence endangered lives and caused the loss of property, summing up to 17 billion of value being lost, according to paragraph 31.
Council, before we proceed, don't you think you're being unjust to this company by saying that they violated the aspect of CSR? Considering that this company, we see in the sale of carbon credits that resulted in the investment, we see there's the Kasiri Cement Primary and Secondary School, Kasiri Cement Educational Bursary, Kasiri Cement Water Springs. We also see that within 2 years, that is actually paragraph 22, the project brought immense economic benefits to the region, which included massive employment and investment opportunities. In fact, during the protests that were there, we had a group of people who are supporting this project was there that you were employing them. Don't you think that you're being unfair in your submission that they violated their obligation in terms of CSR?
Much of that I got for facilitating environmental degradation. We'd like to guide the court and to rely persuasively on the case law of Rylands versus Fletcher in the year 1868. This case established the rule of strict liability, holding that anyone who causes environmental harm must be held liable, and if it escapes their control.
Council, but the relevant Fletcher rule was on private liability and private nuisance, right? And it was about the neighbor principle. Can you align that principle in terms of the aspect of cross-border harm, especially towards another country? Can you also use the same principle in public nuisance, where we have the application of strict liability in public nuisance?
Much obliged, my lord. This is an international case law on Rylands versus Fletcher. Kenya, having been aligned to international conventions, therefore we rely to this case persuasively, and we plead to this court that Animal Limited should be held strictly liable. This principle should be used in this case. In that Animal Limited should be held.
I'm still on the neck. I want to know how we can align the lines of Rylands versus Fletcher in terms of both public nuisance and also in terms of international law principle. Probably a case law that has done that, or you want us to set the first jurisprudence. Any case law that you relied on Rylands and Fletcher to solve the aspect of transboundary harm, especially the lines of strict liability to the extent.
Much obliged, my lord. I seek guidance to be guided by the bench.
Council, kindly don't you have a discretion on this, so kindly wrap up the submissions.
Like to, much obliged, my lord. I'd like to proceed to the last limb of argument, which is violation of the right to a clean and healthy environment. There was a threat to the public health, according to paragraph 23 of this fact sheet. Paragraph 23. Where the public health was undermined and compromised, leading to medical treatment of 6 children and the death of cattle. Under Article 72 of the Malindi Constitution, the court may make any order considering it appropriate to stop or prevent any company that causes harm to the environment. Therefore, we seek to this court that Talman Limited should be held liable. We seek to depend and to rely on Peter K. Govero versus Republic, a case in 2007. The court reaffirmed that the citizen can seek legal recourse, and they highlighted the role of environmental regulations in protecting these rights, holding the council accountable.
Council. Just to wrap up your argument, actually just respond to this question and say the floor. Article 69 of the Malindi Constitution provided that every person has a duty to cooperate with state organs and other persons to protect and conserve the environment, ensure ecological sustainable development. Can you show us as the petitioners what you've done in terms of this cooperation with state organs in terms of protection and conservation of the environment? Yes, respond to that and see the floor.
Much obliged, my lord. I seek to be guided by the bench, and I will request the bench to add me 2 minutes discretionary time to sum up our arguments of the petitioners.
We already reviewed the 2 minutes. Just use 15 seconds to conclude and probably, just your conclusion.
The court, in exercise of its jurisdiction, shall be guided by the precautionary principles as provided under Section 18A(6) of the ELC Act. Talman Limited should be held liable under the precautionary principle as mining acts presented potential risks. They could have taken the precautionary principle, which mandates Talman Limited to take preventive measures to avoid possible impacts, and they should be held accountable for failing to address these potential risks. Thank you, honorable members of the bench. I seek the floor to the next co-counsel.
Greetings, honorable members of the bench. May it please this court. My name is Lashad William Winnie, as earlier introduced. Second counsel for the applicant. I intend to use the 10 minutes of the time allocated to me by this court to canvass on issues C and D and state our prayers. With the leave of this court, I wish to proceed. The petitioners submit that the Republic of Malindi bears responsibility under international law for the transboundary harm caused to Samira. The petitioner asserts that the Republic of Malindi breached its obligation under international law by failing to prevent the transboundary harm that occurred to Malindi. Malindi breached Principle 2 of the Rio Declaration, which emphasizes that states have the right to exploit their resources, but must ensure that the activities do not cause harm to their neighboring states. Persuasively using the case, the no harm principle that is articulated in the Transmelter case that stipulates that a case is liable for harm that spills to other states over its borders and affects the neighboring states. The severe flooding from Malindi severely affected the environment in Samira. Just as Canada was held liable for allowing its activities to harm USA, Malindi should also be held liable for letting the flooding significantly impact the environment in Samira.
Council have cited 2 principles. How are they applicable in Malindi as per their constitution?
The Rio Declaration is ratified in Malindi.
So what says that treaties ratified by Malindi form part of the laws of Malindi? Which article and clause of the Constitution, which specific provision of the Constitution of Malindi allows or gives the state an obligation to follow treaties that it has ratified the international or general rules of international law. Because if we do not have that provision, then it means that reforms the domestic law, that is the constitution and statute. Unless ensures there is a provision that says they must follow those treaty obligations.
Much obliged, my lord. Considering that this case is a transboundary case that affects another state, it is therefore clear that that the case should be addressed using international laws as it affects another state. I wish to proceed. You can answer the question.
How do you attribute the actions of Tamar Limited to the state of the government of Malindi?
Much obliged, my lady. The Republic of Malindi acts as a regulator for the actions of Tamar Limited as the project is happening in that state. I wish to proceed. Just as Canada was held responsible for allowing its activities to harm USA, the Republic of Malindi should also be held responsible for allowing the transboundary harm to happen. The failure of Malindi to put measures that would have mitigated the consequences of the flooding, such as treatment of the waste from the project, clearly shows negligence on Malindi's part, and therefore Malindi should also be held liable for that. The approval of Kasiri cement projects the approval of Kasiri cement projects without proper evaluation. The approval of the Kasiri cement projects happened without proper evaluation on the potential impact of the potential impacts of the project on shared river bodies. The Republic of Malindi should therefore be faulted for failing to uphold its transboundary obligations under international law, which are clearly stated, and it should also be faulted as a regulator for failing to ensure that Kasiri cement projects adhere to constitutional provisions, especially in Article 42, as read together with Article 69 of the Constitution.
Council, it's highly likely that the respondents are eagerly waiting to tell us that the flooding, the landslide was an act of God. So perhaps it would be wise to tell us why, in your view, you would not consider it as an act of God before they come and tell us it is one. Just some foreshadowing before they tell us that it is an act of God. Why don't you consider the flood as some actions that were beyond the control of Tarbu Limited, beyond the control of the state?
Much obliged, my lord. Referring to paragraph 16 and paragraph 24 of the compromise, it is clear that they received, the Republic of Malindi as well as the Talman Limited received warnings, various warnings from different conservation groups that this action would lead to climate change affecting. It is specifically stated in paragraph 16 of the compromise that the mining will increase the risks of flooding. So we do not term it as an unprecedented flooding. The applicant submits that the Republic of Malindi should provide financial compensation to the affected residents of Samira, and it should also undertake restorative measures and restore the damages that happened in Malindi, such as cleaning the contaminated water bodies. And it should also work in future. Malindi should also try to comply and act and should also consult with their neighboring states and prevent future transboundary harm. On to the next issue.
Okay. What provisions or what do you have any legal provision that provides for that aspect of international cooperation?
We base our remedies on the case needs under the river Urugui. On to the next issue, the petitioner submits that the environmental and social impact assessment process was flawed and it violated the constitutional right of public participation. This will be advanced in two themes of argument. On to the first theme, the petitioner submits that it is unlawful, the law mandates for a meaningful public participation, and the applicant asserts that there was inadequate engagement to the members of the community, which hindered effective participation. Regulation 17 of the MCA requires that the project facilitators should conduct at least one public meeting with the stakeholders. In this case, Professor Bakari's team only conducted one public meeting, which was inefficient. In the case of
Council, what amounts to an efficient public participation?
Much obliged, my lord. Allow me to answer your question in the submissions below.
Proceed.
In the case of Robert Gakuru and others plus Kiambu County, the court established critical requirements for public participation, which included that public participation must be inclusive and accessible to all stakeholders. Professor Bakari's team specifically overlooked 53% of the community, denying a larger percentage of the group knowledge of the impact as well as the activities of the project.
Is public participation like voting? Do we have to take the input of every other individual? And two, don't you think that we need to give them a margin of appreciation for saying that they even listen to almost everyone and they could decide on whose, okay, obviously, the decision of the public participation should be on the parliament, right? So let me say on the body that's conducting public participation, don't you think that we can give them a margin of appreciation in the sense that they took consideration from individuals and they say that we are not going with this 53% and only consider 7%?
Much obliged, my lord. It is clear from the compromise that Professor Bakari's team was required to engage at least half of the population of the people affected by the project, but they did not do this. Again, under the environmental and social impact assessment guidelines, there should be a notice of 30 days where the people affected by the project should submit their views to NEMA.
Let me ask, is an agency required to take the inputs of every other individual in terms of public participation? Yes or no?
Yes.
They are required to take the input of every individual.
Yes.
So your input is that public participation is like voting. The numbers matters. It's not about the quality of information.
Much obliged, my lord. About the quality of information, I'll tackle that in the next bit of my submission. But in this case, public participation is basically taking views from the affected people affected by projects.
In Robert Gakuru case, the court clearly provided on probably the reason as to why we need to have public participation. And one of the reasons, or one of the main reasons, was to cross-fertilize the decision that's being made by the agency. Don't you think that the decision to make the final determination rests on the agency and not on?
Much obliged, my lord. the agency should consider the views of the people in making that decision. On to proceeding with my submission, the public participation process violated Article 35(1)(b), where the Professor Bakari's team intentionally withheld critical information on the potential impacts associated with the project. According to paragraph 20 of the compromise, it is clear that the community members were not satisfied with the public participation that was taking place as they approached NEMA in question of the public participation, and NEMA declined to answer. On to the next bit. The environmental and social impact assessment process was flawed and did not adhere to the legal framework provided in the Environmental Management and Coordination Act. Kasiri Cement project is a high-risk project as classified in the second schedule of ERCA. The implementation of the
Council, apologies. I have a question on people affected by the project. Now you are telling us that this project has affected even people in Samira. And now in your public participation, you are telling us we should take into account the views of people that are likely to be affected by the project. So is it your submission that when the Act says we should take into account people likely to be affected by the project, it still talks about the people in the Republic of Samira? What does it mean when it talks about people likely to be affected? Can it be the 47% alone? Can it be the 53 that were ignored? Can it be the 47, the 53, plus the Samira people?
much obliged, my Lord. Referring to the environmental and social impact assessment guidelines, it is clearly stated that on transboundary issues, that the state that is facilitating the project should consult from their neighboring states and get their views on the projects that they want to facilitate.
Two questions. Was the aspect of transboundary harm foreseeable? And two, paragraph 19, Professor Bakari indicated on the hurdles they had in public engagement. And we see in the second paragraph that in our approach, we regarded community members as representative households rather than individuals, a strategy compatible with recognized social impact assessment practice. I can also review to a case, the Manatiele case. It's a South African case, which discusses on the aspect of reaching out first to the most affected. It's like an order of priority. And then the aspect of a qualitative test, getting the best out of the results because we want to cross-fertilize the decision. Don't you think that these people are justified in how they conducted their public participation?
Much obliged, my Lord. The transboundary to answer your first question on whether the transboundary harm was foreseeable, it is clear that there is a shared water body between Malindi and Samira. So Malindi saying that this could have that their water had turned milky. They could have taken a step at that point and prevented the contamination of the river body in Samira. On to answering the next question about whether these people deserve any appreciation. It is true that they use household representatives, but they still withheld information that was crucial to these people. And again, they were required to inform about 50% of the people.
Okay, I'll get to one minute discussionary time to specifically respond to this question and conclude. The question is, what legal provisions provide for that aspect of information? Are they allowed to provide? Does the law allow them to provide information? Like, is it compulsory for them to provide information? Just respond to that issue of conclusion, and then was a yes.
Much obliged, my lord. Under Article 35(1) of the Constitution
Council
of
Council, when you answered that, kindly answer me this, that since you're not satisfied with the measures the government took when conducting public participation, what other measures would you have recommended the government to take when conducting the same?
Much obliged, my lord. Under Article 35A, Article 35(1)A, which provides that every citizen has the right to access information held by the state or another party. So it is my provision, it is my submission that Professor Bakari's team clearly violated that right by withholding the information, the critical information. To answer your question, my lord, about what other measures would have been taken, they would have ensured that the National Environment Management Authority would have ensured that the environmental assessment process was done thoroughly, and according to the Environmental Act, it is clear that an environmental, social, and social impact assessment should take at least 30 days, of which their environmental took less than 3 weeks. I humbly request the judges to infer the prayers in my memorials. Seek the Lord to the bench.
Thank you for your submissions, Council.
Greetings, honorable members of the bench. May it please the court. My name is Oware Kelidea, the lead counsel appearing on behalf of the respondent. Appearing with me is fellow counsel Cyrus Karaoke. Together, our team code is number 27, and we are representing the respondents in this matter. I plan to use 12 minutes of this honorable court's time to address issues A on jurisdiction and D on public participation. My co-counsel will use 8 minutes to canvass the position of the respondents on issues 2 on greenhouse gas emissions and 3 on transboundary harm. Unless directed otherwise, I will begin. Honorable members of the bench, desperate times call for desperate measures, and as a government that comes face to face with the adverse effects of climate change and financial constraints, the state of Malindi has taken reasonable steps to ensure that it balances the competing priorities of pursuing economic development with environmental conservation. Their efforts, therefore, need to be recognized and acknowledged, and the allegations of the petitioners be done away with. The first issue brought before this court is on the preliminary matters where the respondents admit that this court lacks the requisite jurisdiction to hear and determine issue 3 on transboundary harm, that the respondents indeed have standing, and that issues 2 and 4 brought before this court are inadmissible. Starting with local standing, pursuant to Article 22(2), both C and D of the Constitution of Malindi, the respondents admit that they have standing, since the provisions cited are of the implications that persons and organizations acting in public interest have standing to constitute a court proceeding claiming that a right of fundamental freedom has been violated, threatened, or infringed. In matters of admissibility, it is our submission that the issues 2 on greenhouse gas emissions and 3 on the validity of the environmental and social impact assessment are inadmissible for failure to comply with the doctrine of exhaustion of local remedies. Article 159 of the Constitution of Malindi mandates the judiciary to uphold alternative dispute resolution mechanisms. And in the case of Geoffrey Mugiga Kabiru versus Samuel Muga Henry, a case that was heard and held before the Court of Appeal, whose decision is binding before this honorable court, In 2015, the court held that where an alternative dispute resolution mechanism exists, the same be exhausted before the jurisdiction of the court is invoked. Since the petitioners, in this case, when you move with me to paragraph 32 of the fact sheet, once they felt aggrieved, did not approach the National Environment Tribunal, they are therefore in violation of the doctrinal exhaustion of local remedies.
Council, I have a question. And this question comes from the R versus IEBC. R versus IEBC. And the court clearly provided on an exemption towards the adoption of local remedies. And this exemption was on the aspect of the value, the national values. If it appears that it will be hard to realize national values by moving to the national environmental, the NEMA tribunal, then this court may be allowed to allow and read that case. Don't you think that the aspect of first transboundary harm and also the aspect of failure of public participation, which is part of Article 10 of the Constitution, violates the national values, and this case should allow that?
Honorable member of the bench, thank you for that question, my lord. First, it is our submission that the issue of transboundary harm is not being faulted for being inadmissible. Our submission is specifically on issue 2 on greenhouse gas emissions and issue 4 on public participation. In matters of public participation, the exceptions, the respondents are privy to the fact that the doctrinal exhaustion of local remedies is not absolute and is therefore subject to limitation. The onus to prove that this case is one that is similar to the one that was mentioned in the case of R versus IEBC is not on the respondent, it is on the petitioners. Their reliance on inadmissibility of this case was pursuant to the argument on urgency, members of the bench, which is not under any case, members of the bench, it is not considered as an exception of the doctrine of exhaustion of local remedies. We persuasively invoke the case of Alfred B. versus Ghana before the African court, where the court under paragraph 13 gave out the 3 circumstances that can warrant an exception on the application of the doctrine. They say that the doctrine does not apply to where the remedies are unavailable, ineffective because they are incapable of offering redress, or inappropriate because of bias.
Also, that is the same reason we talked about urgency, because justice delayed is justice denied, so it is ineffective in that regard. And my question would be, if you are giving the tribunal jurisdiction, then take us to section 129 and show us the specific provision here that gives the tribunal jurisdiction to hear issue.
Much obliged.
Greenhouse gases.
Much obliged, honorable member of the bench. The section that we are relying on in the Environmental and Management Coordination Act is section 129(1) that grants the National Environment Tribunal power to hear cases regarding the liability for environmental damages and also issues on the validity of environmental and social impact assessment prior to the awarding of licenses. It was therefore an effective remedy that the petitioners ought to have sought. Unless directed otherwise, I will move to matters of jurisdiction, where it is our submission in the respondents that issue C on transboundary harm is admissible, this court has no jurisdiction to hear issue C on transboundary harm. Honorable members of the bench, jurisdiction is everything, and without it, a court has no power to take even a single step. This was the holding of the Court of Appeals binding decision in the case of owners of the motor vessel versus Caltex Oil Limited. Further, the Supreme Court, whose decision is also binding before this court, in the case of SK Macharia versus Kenya Commercial Bank Limited, held that the jurisdiction of a court can only flow from statute or the Constitution or both. And the petitioners have made a futile attempt to say that this court has jurisdiction on issue C pursuant to section 13 of the Environmental and Land Court Act, read in conjunction with Article 162(2)(b) of the Constitution. It is our submission that these provisions only apply within the purview of Kenya and do not extend to international obligations. as harsh.
But also, section 13, is that a correct reading of section 13(1)? That says that this court has jurisdiction to hear all matters that concern environment and land laws applicable in the Republic of Malindi, which still counts for the international laws that apply in Malindi. So, are you denying us jurisdiction, even where we have jurisdiction to hear matters that concern international law? And in any case, does it mean that international law that we are talking about here is the international law only applicable to us? International law is applicable for the principles, basically. The international principles, they count as international principles or general principles because they apply to all states. So how are we going to say that we have jurisdiction to hear matters concerning environment and land laws applicable in Malindi? Those are international laws. But international law applies to all the other states. So how do we limit that jurisdiction as per section 13(1)?
Much obliged to answer your question, my lord. And as harsh as this judgment may sound, honorable member of the bench, allow me to guide us to the Court of Appeals decision which is binding in the case of Kenya Ports Authority versus Modern Holdings Limited, where the court clearly stated that jurisdiction is not a matter of what the judges themselves think. It is a matter of statutory or constitutional conferral. And we are privy to the readings of section 13(1) of the Environment and Land Court Act that states that the ELC in fact has jurisdiction to hear matters relating to land and environment on laws that are applicable to Kenya. However, it is important for us to note that this statute itself has placed a limitation stating that laws that are applicable to Kenya, it does not extend to where obligations of a state to another state are cited. And this was the holding in the case of R versus Nema Experte Akaba Investment Limited.
Then what laws are applicable in Malindi?
The law is applicable, member of the bench. The law, the principle on transboundary harm. Our submission, however, is not that the principle of transboundary harm is not admissible in Kenya. It is because there is a rise of an obligation of the state of Malindi towards another state. Allow me, member of the bench, to cite the case of R versus Nema Experte Akaba Investment Limited, where the High Court stated that environmental matters that extend beyond the borders of Malindi, and where there arises obligations of the state towards another state and outside the jurisdiction of domestic courts. If that suffices the nature of my submission on the first issue, allow me to guide you to the the fourth issue brought before this court, where the respondents assert that the environmental and social impact assessment process.
Counsel, sorry to take you back. You've said that issue C is Samira concerned in issue C?
Honorable member of the bench, yes. Principle 10 of the law declaration, which gives rise to the principle on transboundary harm, states that the principle means that the state of Malindi has an obligation to prevent transboundary harm to another state, which is the state of Samira in this case.
So, Counsel, my question is simple. Is Samira a party in these proceedings?
No, it is not a party in these proceedings.
To move in line with that, the two questions. My question is, the High Court, let me say the Environment and Land Court, can also interpret the laws, right? These courts are not interpret the laws, right?
Yes,
and we have the laws that provide for the aspect of the treaties and conventions being part of the laws of the state. When a state violates these treaties and conventions, can the court interpret this aspect of the violations by the state, specifically to its obligations in international law, whether it affects other states or not?
is this court bound in its interpretation and application?
Honorable member of the bench, I would like to simplify your question in two parts. In matters of international obligations of the state towards its citizens and how it acts, where there is no obligation towards another state, then it has jurisdiction to handle that matter.
Counsel, that's a very serious response. My question is, we have obligations of treaties and conventions. This obligation is actually an obligation to the treaty. And this obligation, if you violate this obligation, actually violate the obligation to the treaty and also to other states using the aspect of the government's obligations. So the question is, if this violation happens, don't you think that this court will be allowed towards the interpretation and application of these aspects of the violation?
In this case, not, my lord.
Council, still on the jurisdictional issue, you know, jurisdiction cannot be arrogated through judicial craftsmanship. It is a simple reading of the act. A simple reading of the act says any other law applicable in the Republic of Malindi, any other law. But now you're telling us, no, when the law, the international law applicable there is transboundary harm, no. But it is not limited when we come to section 13.1. Is that not arrogation of jurisdiction?
Seeing that the court wants to deeply delve into this issue, I think two discretionary minutes to comprehensively answer your issue, presiding judge.
Because of time, we will only have a minute.
Thank you for your generosity. It is not the position of the respondents on their own opinions. It is the interpretation of section 13.1 of the Environmental and Management Coordination Act, pursuant to the case of Albert Nema Expert Akaba Investments Limited. They were positioned with a case that involves the international obligations of the state to another state, and they held that should the makers of law have wanted international obligations towards another state to be part of the jurisdiction of the ELC, they would have expressly stated so. It is not subject to our thoughts and our opinions.
Then tell us, does issue C now stand and handled, and where do you suppose the Attorney General will further issue?
In this case, Honorable Member of the Bench, the court should be referred, the Attorney General, the case should be brought before the International Court of Justice because it has jurisdiction pursuant to Article 36(2), both C and D of the ICJ statute. If that suffices, members of the bench, allow me to take you to issue 4, where it is the respondent's assertion that the environmental and social impact assessment process, that the respondents followed due process and therefore upheld the right to public participation. We shall address this issue in 2 heads of argument, first on due process and second to demonstrate that the public participation carried out was effective. The petitioner has cited the provisions under Regulation 17 of the Environmental Regulations, or rather the Environmental Impact Assessment and Audit Regulations of 2003. They have clearly stated that the government is required to carry out 3 public meetings and we only carried 1. However, it is our assertion that they have conveniently left out the provisions under paragraph 19 of the fact sheet. When you move with me, members of the bench, we can see that the government made various steps to carry out or ensure that the citizens have been accorded their right to access to information. We developed a multi-channel communication approach where we included local radio broadcasts, public announcements, and even collaborations with community leaders. It is our assertion, therefore, that we did, in fact, give them a reasonable opportunity to know about the issue. In matters effective,
Counsel, I don't contest the provisions of paragraph 19. However, when you say that you accorded them a reasonable opportunity to know about the issue, I would like to guide you to paragraph 18 of the fact sheet, where you conveniently left out the risks associated with the project. So kindly guide us on whether this was also a part of what you are talking about, this public participation.
bear in mind that access to information, we relied on Article 95, but I will use the requirement in the Moot case in case that you have to give people access to information, and channels used to convey the information should be available to the relevant citizens. So we do not want just use radios, the other levels, but knowing that 53% were intentionally excluded from access to such information.
Much obliged to answer those questions, honorable members of the bench. It matters the right to access to information provided for under Article 35 of the Constitution of Malindi. Allow me to guide this court. In the case of Katiba Institute versus President's Delivery Unit, before the Court of Appeal number 234 of 2017, where the court held that it matters the right to access to information. It can only be violated where the information withheld substantially distorts the subject matter in question. It is our position that the information in this matter was not fundamental because it did not change the perception or the intention of the government. We did not approach them with information of construction of a dam instead of construction of a mine, and therefore the right to access to information cannot be held to be violated because it does not significantly and substantially distort the subject matter in question.
Council, I'll lead you to paragraph 18, and this is like probably away from the subject matter, but an emotive issue. These community members reached out to seek the aspect of probably, okay, they had sought engagement, but in paragraph 18 we see that what was disclosed was the risk identified, right? And the resultant effect of this is that we see a huge number of these individuals dying based on the same risk that has been pointed out. So this means that these people died out of the failure of the government to give them information. This means that probably if these people had known that they had these risks probably through the mining, some of them would have embedded death. But in this case, these risks were not pointed out. So this means that it's like the government set a ticking bomb to the individuals, whereby the government is obligated to protect these individuals' lives. Can you submit in line to that?
Honorable member of the bench, I take note of your concern. And
Plus, you've talked about the risk not being a fundamental matter. Kindly address us on what was a fundamental matter in this case, given that the environmental and social impact assessment report, the main reason for it being carried out is also to identify the potential risks involved in projects, given that these are high-risk projects.
thank you, honorable members of the bench, for those questions. Seeing that my time is greatly lapsing, I seek 2 discretionary minutes to address your issues and conclude the matter. Thank you for your generosity. On what amounts to a fundamental, honorable member of the bench, allow me to first sympathize with those that were affected, honorable members of the bench. The intention of the government, pursuant to paragraph 17 of the fact sheet, was to indeed reach each and every community member that was affected. And it would be unwise or imprudent for this court to fail to consider that under paragraph 19, we faced various challenges that needed us to be more malleable and innovative in the way that we carry out public participation and accommodate
the working on the sleep and ground when you talk about having constraints, because the Moot Basic case tells us to only consider logical constraints. Now, the constraints you are telling us here are the topography and the financial constraint. Now, you are given money one. For the topography constraints, you are told to use media that can be accessible to the citizens. How is that? How are the constraints you are talking about logical constraints?
Honorable member of the bench, it is our assertion that these are still logical constraints because the rugged topography is not in a solid, It is married together with the fact that these community members live in a widely separated manner, putting into consideration that we are also having staff resources being limited, member of the bench. It is unwise for us to expect that each community member would have been reached. And further, in the case that you have so powerfully cited, Honorable Presiding Judge, the case of Moot-based local community versus the Permanent Secretary Minister for Energy, the fourth requirement for public participation states that it is not mandatory that each and every community member affected gives their views. And further, the South African Constitutional Court, in the case of Nuclear South Africa versus Minister for Health, held that public participation need not be carried out in arithmetic precision. The use
in the same holding that not everyone should be considered everyone's views, it also says there must be diversity and inclusivity. Where is the diversity here when 53% are not there? And again, it says you must show evidence that all the views were considered in good faith. So the views of those who came later to ask about the project and did not even tell them about the risks. Where is the good faith of their views?
Honorable member of the bench, your first question on us not addressing, overlooking the 53%. It is our submission pursuant to paragraph 19 that we use representative form of consultancy. This is not an alien situation. The Court of Appeal, in the case of Momo Matemo versus Trusted Society of Human Rights Alliance and others, in the year 2013, held that representative form of consultation can be used, especially where the circumstances have pushed the respondent or the government to apply such. The widely separated communities and the married together with all the other challenges that were included in the report are a justification of why we used a representative form of consultation. In matters good faith, as is seen under paragraph 17 of the fact sheet, when we embarked on carrying out public participation, it was our intention to ensure that we reach each and every community member. We did not severe a certain section and not consult the member of the bench. We used households.
Did you provide reasons as to why you rejected? Because I think the recent Supreme Court case, which is also binding this court, the Finance Act decision, it provided that the parliament must provide, or let's say the agency, the party of the agency conducting public participation, must provide reasons as to why you're rejecting these views. In this case, did you provide reasons as to why? We actually agree with the argument that you cannot take all the arguments. And we also agree with the argument that it's the some of the parliament to decide what these courts are not go against that. But did you provide reasons to these people? Because there's sovereignty being belongs to the people. Did you provide reasons as to why you did 53%?
Honorable member of the bench, thank you very much for that question. We did not reject 53% of the views. 53% of the affected population was not consulted. Why? Because we used representative form of democracy. And on the views that were given by these people, allow me to rely on the case before this honorable court, in the case of Ken Kasinga versus Daniel Kiplagat Kirui, in one discretionary minute, if the court may allow. Thank you very much. The court acknowledged that government agencies still have a discretion to weigh important factors. In this case, we were, as a developing country, a middle low income earning country, the need to pursue economic development is important. This is an action for the people, and therefore it is a justification on why we carried out public participation in such a manner. If that suffices the nature of my submissions, honorable member of the bench, I have reached the end of my submissions, and I seek to cede the floor to my co-counsel to buttress the position of the respondents on the remaining issues. Thank you very much.
Honorable members of the bench,
my lords and my ladies, greetings and may it please the court. As earlier introduced and for the purpose of record, my name is Cyrus Karaoke, second counsel appearing on behalf of the respondents. I intend to take 8 minutes of this honorable court's time to respond to the petitioner's assertion with regards to the second and the third issue presented before this court. Unless the bench directs otherwise, I wish to proceed to our submissions. Thank you, Your Honor. Honorable members of the bench, the second issue pertains to whether tobacco industry can be held liable for greenhouse gas emissions, environmental degradation, and for exacerbating the climatic vulnerability of the Kasiri region. Your Honors, it is our submission that liability cannot be imposed on tobacco industry. And on this, we will rely on 2 lines of argument to respond to the petitioner's assertions. First, that the flooding that occurred amounts to an act of God, and therefore the chain of events that resulted from the floods cannot be attributed to the thermal industry. Your Honors, move with me to paragraph 25, where we see a clear picture being painted. There were unprecedented rainfall, and it is clearly stated a rare deluge which had not been witnessed since or for decades. Your Honors, we submit that the severity of these floods amount to an act of God. And Your Honors, in the case of Kenya Ports Authority versus East African Power and Lighting Company Limited, decided before the Court of Appeal, it was stated that for natural disasters that are to such a magnitude that is out of the control of the state, then the liability cannot be imposed, Your Honors, on the respondents.
Counsel.
Yes.
Well, we do agree with you that the floods and disasters can be considered as an act of God. But don't you think that this whole situation could have been avoided if simply the government could have adhered to the results of the social impact and assessment tests?
Thank you, Your Honor, for your question. And to respond to the issue you raised, we still rely on our limb of argument that they were an act of God. And further, we wish to rely on Article
Counsel, you remember me asking counsel for the petition that what if the respondents tell us it's an act of God. The message is go to paragraph 20 of the facts. Was it 20? Basically, the counsel for the petitioner showed that these whole floods and the potential risks were foreseeable because Professor Mjwandi had said that the project exposes to the worsening of the floods. And I'll confirm the specific paragraph, and I'll tell you.
Much obliged, Your Honor.
Paragraph 16, specifically it was paragraph 16. Professor Bakari and her team noted that one of the risks of the project could cause, 1, the possible collapse of land where the mining activities were intended to occur. And now the rest, the next paragraph in her ESIA report, Professor Bakari detailed that Mirenga Valley was categorized as a soft grading, and therefore 1, that surface and underground mining could destabilize the land, increasing the risk of flooding. So we are not refusing, yes, the flood is an act of God, but mining, you are already told it increases the risk of flooding, landslide, and ecosystem collapse, but you still continue with the project anyway. So, what measures did you take? Yet you are aware, when you do this project in this valley, there is an increased risk of flooding. Despite the fact that there could be any floods and whatever, there is an increased risk. So we are concerned with the negligence as far as the increased risk is concerned for the flooding, the ecosystem collapse. Then we can go to the health impact.
Much obliged, my lord. And to address your concern, I wish to rely on the same paragraph that states that there was an increased risk of flooding. It was not stated that there was an increased risk of flooding due to the unprecedented nature of the floods that occurred thereafter. Therefore, with regards to the said paragraph, it was just for normal flooding, not for the unprecedented nature of the floods which later occurred.
So even for assuming there were normal flooding,
Assuming even if there were normal flooding is happening, not even the unprecedented one, what are the measures we see the government took even after they note this area has an increased risk of flooding in case of heavy rain? So are there any measures that the government took so that even if there is unprecedented flooding, there could be at least minimal damage than what we see? Was there any measures taken by the government to consider the risk that is there? Even if there is minimal rain, there is increased risk. So let's take these measures so that in the event of the unprecedented, then there are minimal damage.
Much obliged to answer your question, my lord. And to answer your question, it is clear from the fact pattern that the respondents have taken precaution with regards to combating climate change. And Kasiri as an area that is faced with the problem of climate change and its adverse effect thereof, we submit we have taken measures such as your, my lord, from
the issue is the Biaka Valley. Forget about climate change. Let's go to the valley. You are told mining in the valley has an increased risk. So, let alone the climate change and other factors, what do you do in the valley as far as the mining is concerned? So, because we even see later when mid-morning the rain ceases a bit, you tell the miners to go back to mining and they collapse in the mines. Because what are the measures taken in the mining at the valley?
Thank you. To respond to your question, Your Honor, I would like to rely on the case of Ken Kasinga versus Daniel Kiplagat Kirui, decided before the ELC, where it was stated that for ESIA reports, they are merely advisory. Therefore, it is not binding on the respondents to take every advice given out in the report into account without.
Council,
Yes.
the NEMA guidelines. One of the things in the NEMA guidelines is the fact that in terms of the environmental impact assessment, EEIA, or the environmental social impact assessment, all the things that needs to be done is when there is the potential risk or harm, what needs to be done is an action plan that's there to mitigate these potential risks and harm. And the question is tying it to the lead judge's question. What has the government done to ensure that in any case, right, these risks that are potential, because when it comes to environmental matters, the risks may destroy our whole society, right? So, and I think we also see that in the nuclear health test. So my question is, what has the government done to ensure that in any case, these risks, including flooding and probably the soft ground issues, is increasing the risk of flooding, landslide, and ecosystem collapse? What has been done to ensure that this harm does not harm the communities living within the area, as well as the laborers on site?
Thank you, Your Honor, for your question. And to respond to your question, when the floods ceased, or when the rains had stopped, or when the rains were continuing, we asked the laborers to cease the operation. Therefore, that was one of the precautions we took to ensuring that to ensure that the miners were not adversely affected. Furthermore, Your Honor,
Let us go down to the health impact.
Before we move to the health impact, in paragraph 58, right, we see contractors for the Kasiri project, Kasiri cement project urged that the miners report for work, stating that the weather condition was manageable in operation. This in between the floods, that the flood has always ceased. And still on unprecedented day, we had 200 miners, both men and women were working. We had a tragic moment for this country, a painful moment where 33 miners were buried alive. What measures have you put now that you're saying you are blessed to ensure that these people will not be injured at these occurrences as a government?
Much obliged, Your Honor. To respond to your query, the fact patterns are silent on whether the government took any steps to ensure that the mines did not collapse. However,
as the council to the respondent to the mouthpiece of the government, the petitions are submitted that people died because of their negligence.
Your Honors, and we are sympathetic to the people that died in the mines. However, the petitioners have not been able to establish causation of the causal link with regards to the death of the miners. We are submitting that the deaths cannot be attributable to the state. The state did not cause the death it was the collapse which was caused by the unprecedented nature of the floods. Furthermore, Your Honors, relying on Article 23 of the draft articles on state responsibility.
You are admitting you make no changes to the nature of the mining sites and still say that you are not liable when the mines collapse on people. Because I'm expecting that the government should have improved the state of the mining sites. Because even if they do not expect unprecedented rain, they should expect increased floods because of the nature of the mines as we have been told in paragraph 16.
Thank you, Your Honor, for your question.
And to add on that, can you align his question to the precautionary principle? Kindly align the question to the precautionary principle. Did you take any precautions? Because the precautionary principle is an obligation of the state to ensure that these things are not happening.
Yes, we did, Your Honor. We took the precautionary principle into account, and that is why we asked the miners when the rains were continuing to cease the operation. Therefore, with regards to the precautionary principle and with taking into account the likelihood of the mines collapsing, yes, we did take precaution. Furthermore, Your Honors, it is still our stand that the collapse of the mine, the flooding, and the unprecedented nature of it thereof is an act of God and therefore cannot be held, the respondents cannot be held liable for such.
So now, if you are still going to dwell on the argument on act of God, we will go to the health impact so that we see whether the same is still an act of God. Bear in mind that the right deposits were still there, but the water was clear. Now it's milky after you have begun your mining operations. So, the water has been flooded by animals, they are dying. The Mienga River has flooded. It is now affecting the Samira as another state as it flowed to the ocean. So, how do you, or what do you say on the health impact as far as lime poisoning is concerned?
Thank you, Your Honor, for your question, and I'm much obliged to answer it. And to respond to your question, I wish to rely on the same paragraph where it is stated that the water began to turn milky. However, this has not been linked with the activities or the mining activities by thermal industry. Furthermore, Your Honor,
On a balance of probability, water before the mines was clear. Is that true?
It is.
Water after the mining operations have begun is now turning milky. So it beats logic when we say that there is no causal on a balance of probability. Every reasonable man, a reasonable bystander can tell that on a balance of probability this could be the cause of the lime poison. So how do you dispense such a burden of proof?
Much obliged, Your Honor. To respond to your query, kindly move with me to paragraph 10, where we see that Kasiri region has limestone exposed. Your Honors, please submit that as per basic science, limestone is made up of calcium carbonate, which is soluble in water, Your Honors.
Counsel.
We therefore submit.
But the first question that the court had asked you was whether the water was clean, and you responded with that affirmative yes.
Yes.
Right?
However, it cannot be linked to the activities of thermal industry. It has
So,
not.
Out of nowhere, after you started mining, the carbonate now start being soluble. Right?
We submit that it is soluble from
In the start.
yes.
But before, it was not causing any harm to the people. The water was not touching it. But then suddenly, after you started mining, it starts turning guilty. Don't you think that you can really attribute that to you on a balance of probability?
Your Honors, and to respond to your question, I wish to rely on the case of Wilshire versus Health. Sorry for that. I wish to rely on what the court judge has cited, alternative possession. And one of the alternative possession in this matter is the solubility of the limestone that is in Kasiri. And therefore, when you cannot establish possession with regards to the mining activities of thermal industry, then you can attribute.
My question is, we don't need to prove full possession, right?
Yes.
We can still attribute partial contribution of that to the state or the act, right?
Yes.
You agree?
Yes.
I think into a case, it's called Sheila Zia versus WNA at the Supreme Court of Pakistan. And my question, and that case provided the aspect of even a small or partial contribution are legally causal when it comes to human rights. They have submitted on the aspect of environmental rights. Don't you think that we can link your actions as a cause towards what they have already have in the aspect of violation of their rights?
And to respond to your question, Your Honors, the proving of causation is based on a balance of probabilities. Therefore, the two alternatives can be the cause. We submit and we accept the fact that the two alternatives can be the cause of the contamination of the water. However, the onus is on the petitioners to prove that the activities of thermal industry was the substantial cause of the contamination of the water. They have failed in this regard, and therefore.
Council, the petitioners were very brief on that issue. That one, water before mining was clear. Water after mining operations began is now turning milky. There is no way the flooding in paragraph 16 has not already begun. So where do you want to tell us that the line has started draining to the river, or what happened in that regard? If you are saying that indeed the line could have dissolved in the water without the mining operations, without rain, how did that happen? Because as far as paragraph 16 is concerned, there is no flood until that time. So how did that happen?
Thank you for your question, Your Honor. And to respond to your question, it is our submission that in the fact pattern, this is not the only rain that has occurred in Malindi. There have been more rain occurring in Malindi. Therefore, the rain that occurred previously could be the reason for the line dissolving. Furthermore, Your Honor, we submit that as lime is contained in the rocks, then underground water from the Kasiri region can be responsible for the dissolving of the lime.
Also, you are saying there has been rain even in other events. And I want to agree with you, yes, it has been raining and the lime has never dissolved.
It is not stated anywhere in the fact pattern.
Because we have been told that the water has been clear. That is to me that even when there was rain in the other events, the water was still clean. So when the mining operations began, that is when the water began to turn. So let us not use the issue of dissolving, because even before, it should have started dissolving before even the operations began. Because we should have been told at least the water was still turning a bit, but now it has turned more. Then in that case, we would argue out that you are contributing the latter contamination. But the fact pattern is clear that even with other rains, even in other periods, the water has always been clean. So let's get the digits of another day.
And I think I also have a question. On paragraph 29, we see the aspect of anticipated everyday purpose, which is a lot of people, right? But then paragraph 29, we see that the second factory was expected to close until it was sent to the same operation. However, 1 week later, the project was still running while a few of the activities were allowed. Don't you think that don't you think that as a government you had an obligation of ensuring that this company does not continue with its aspect of causing harm to the people?
Thank you, Your Honor, for your question.
Counsel, you have a discretionary duty to conclude and answer any questions.
Thank you, Your Honors. And to respond effectively to your responses, I wish to be given 2 discretionary minutes from the bench.
You have one.
Your Honors, to respond to the lead judge question on contamination of the water, we submit that contamination can take time. Therefore, rains before may have progressively contributed to the contamination. Furthermore, it has not been established on a balance of probabilities that the activities of thermal industry are responsible for contamination of the water. And for this, I wish to rely on the case of Lucia versus Essex Health Authority, where it was stated that where on a balance of probability there exist possibly two causes for damage, then it has to be proved that one of the attack causes contributed substantially to the damage. We submit that the petitioners have not been able to prove that substantially the mining activities of thermal industry contributed to the contamination of the water. With the bench's permission, I would like to proceed to my last issue, and that is on whether the state of Malindi can be held liable for the transboundary harm occurring to the state of Somalia, where it is our submission as a respondent that they indeed cannot be held liable. And for this, Your Honors, I wish to rely on paragraph 15, where it is stated that Talmo Limited is a multinational corporation. Your Honors, marrying this with Article 8 of the draft articles on state responsibility for international wrongful acts, then liability cannot be imposed. This is because thermal industry is a non-state actor, and as per the said article, governments cannot.
Also, I don't work with contracts. So despite the fact that we are a multinational corporation, that Tarbu is a multinational corporation, you are working under a contract with the corporation, you can terminate the contract, so you have control on whether they continue working within the state or they cease the operation within the country. So how do you say you don't have liability, yet you are working under the contract? What did you do under the contract to show that you are not continuing to agree with the provision of their services? Because if you two are working in the same contract, then we can say you are liable under the actions they are doing unless you show you have departed from the operations. So did you terminate the contract with Internal Moot, or you agreed that they continue operating in the country?
Thank you, Your Honor, for your question. I'm much glad to answer it. We are privy to the fact that it is a contract. However, Tamil industry has corporate autonomy. And for this, I wish to rely on the case of Bosnia versus Serbia, which established a three-part test for effective control. And we submit that the state of Malindi has not met the three-part test has not been met. First is that the authority has to be seen to direct or control the actions of the non-state actors. Your Honors, we submit as per the fact pattern and as per the submissions of the petitioners, we do not have direct control over the actions of Tamil industry. Furthermore, we have to...
For direct control, you have to be involved in the planning, in the financing, in whatever. I think you are involved in that because the money came from the World Bank. I believe you are the one who have the money. The planning, you are the one who involved in them. You will be contracted to be part of the project. So you are involved in the planning and financing of the project that Tamil are taking. So how don't you have direct control? Just improve the finances.
Thank you, Your Honor, for your question. By the mere fact that we provide financial support to them does not mean that we have direct control. Your Honor, as per the said case, Bosnia versus Serbia, the three-part test also provides for planning, supporting in the execution of the activities. With regards to oversight and planning, we submit we have no direct control since they are a multinational corporation, and in as much as we are in a contract with them, they have corporate autonomy. That is subject to the laws of our country with regards to the way business is conducted by corporate institutions.
What relief then do you seek so that because of time?
Thank you, Your Honor. The relief we seek is that for this court to find that it lacks jurisdiction with regards to the issue to do with transordinary harm, since issues of international obligations arises, and as my co-counsel has presented, the environment and land lacks jurisdiction with matters that international obligations arise, that is obligations to other states. Your Honors, having come to the end of our submissions, I wish this court to infer our prayers from our written submissions.
May it please this court, thank you, Your Honor. We seek to rebut the point on transboundary, the issue on transboundary issue. That it is not admissible before this court. Under ELC Act, Section 13(1) of the ELC Act, it explains the jurisdiction of ELC, stating that it has power to determine over environment cases, making the issue at hand fall within the precincts of ELC's jurisdiction. Also, it is false to say that there was precaution taken in the matter. In pursuant to paragraph 28, minors had to appear to work, and it caused 33 minors to die. Following the requirements of public participation, which states that public participation should be held in a place accessible to all stakeholders. So using the rugged topography as excuse is not valid. The state is a regulator of their projects within the states. Having said this, the respondent should be held liable for the deaths of the people, the state. And unto our last rebuttal, we agree that the line dissolves, but it dissolves to form a white solution, which clearly shows that the line was responsible for the contamination. Thank you. We seek the floor back to the bench.
Thank you. The session is closed. I think we shall let them tally. And yes, the marks are very beautiful to see. I like you guys. I think remember some photos are already in there. Go check Lano. Some photos are already there of you guys presenting. You guys look beautiful. Some of the most handsome and beautiful ladies here, handsome and beautiful men. Man. The light skinned men. The light skinned ladies. Okay, except one, but the light skinned ladies. Alright. Yes. And our lovely faces. Please, yes, I'm supposed to end.